Okay, so greetings, class. I'm going to talk in this little lecture here about the issue of whether we need a codified constitution, whether the advantages of a codified constitution now outweigh the disadvantages. So to begin with, as we know, a constitution, just to be clear about our terminology, a constitution consists of the rules, processes, and procedures by which a country is governed. If a constitution is codified, these rules are clearly set out in one single official document. Now, the vast majority of the world states have codified constitutions, but Britain's constitution is uncodified. So the rules and processes by which it's governed are dispersed across, frankly, a bewildering array of parliamentary statutes, historical documents such as Magna Carta, the Bill of Rights, case law, and even unwritten conventions and principles such as common law. Now, in recent years, the case for a constitution in which rights are more firmly entrenched, a codified constitution, has been growing as successive governments have reacted to the terrorist threat in ways which arguably undermine our fundamental freedoms, such as the right to protest, the right to privacy, and habeas corpus. Now, this essay will look at three key areas, not this essay, this lecture, we'll look at three key areas of this debate, at issues around principle versus pragmatism, issues of power, parliamentary power versus judicial power, and the processes involved around creating a constitution. Now, a major argument, to begin with, a major argument in favor of Britain's uncodified constitution is that it allows for great flexibility. And this is particularly an argument put forward by conservatives. I'll explain why after I've explained the argument. Now, the British Constitution, it is argued, is what's called an organic constitution, and that it has been evolving and adapting over the centuries, gradually evolving in response to changed circumstances, giving parliaments and governments of the day the freedom to respond pragmatically to new situations that arise. Now, the reason I said this argument is particularly put forward by conservatives. Conservatism is an ideology that particularly values pragmatism, the flexibility of responding to changing circumstances rather than being driven by a fixed dogma or principle or ideal. And it's also an ideology that prioritizes security over freedom. Now, so to give you an example of what I mean by this, a recent example of the government being free to respond flexibly to changing circumstances came with the government's response to the terrorist threat. And in the weeks following the September 11, 2001 attacks on the World Trade Center and Pentagon in the US, the UK government pushed legislation through Parliament that allowed foreign nationals to be detained without charge indefinitely if they were suspected of involvement in terrorism, despite the fact this clearly went against the now 800-year-old principle of habeas corpus established in the Magna Carta, right? Key constitutional principle, habeas corpus, the idea that you have power over your body, literally habeas corpus, to have your body, have your corpse. So no one should be able to take control of your body, no one should be able to imprison you, therefore, unless due process is followed, there's been a charge laid against you. Yep, you shouldn't be able to be just detained by the state authorities without charge. Now, so this act actually scrapped all of that in the case of foreign nationals. It's actually the police can detain foreigners for as long as they want without charging them if they suspect involvement in terrorism. Clearly against the principles of habeas corpus. So clearly, in that sense, unconstitutional. Now, therefore, this act of parliament that allowed that would have been much more difficult if we'd had a codified constitution, as codified constitutions tend to be entrenched. An entrenched constitution, remember, means one that is difficult to alter. Actually, strictly speaking, what an entrenched constitution is one that requires some kind of special procedure to alter it over and above the normal lawmaking procedure. So they wouldn't have been able to pass that law without first altering the constitution, which would have required some kind of extra process, like maybe a supermajority in parliament, maybe a referendum, etc. So this could potentially have left Britain more exposed. Supporters of uncodified constitution would say, well, if we'd had to go through all of that, this could have left Britain exposed to a terrorist attack of its own. Other anti-terror measures passed by Parliament have included the extension of detention without charge for all citizens from 7 days to 14 days, then to 28 days under Tony Blair's government. We've seen laws against unauthorized protests within a mile of Parliament. In 2005, this law was passed. And we've seen laws allowing the government access to citizens' internet records, the so-called Snoopers Charter of recent years. Now, all of these were easy to enact, given the flexibility of Britain's uncodified constitution. The government didn't have to go through any special procedures, despite the fact that these undermine certain long-held rights. Supporters of the current situation said this is good. This gives the government the power, the flexibility it needs to respond to the terror threat as it deems necessary. However, for supporters of codification, this flexibility is exactly the problem. Many people, particularly liberals, have argued it's actually too easy now for the government of the day to make whatever constitutional amendments it likes, even if this means scrapping centuries-old rights, because governments can simply use their majority in the House of Commons, if they have a majority in the House of Commons. Of course, the current government doesn't. But most governments have a majority in the House of Commons. They can use this majority to push through whatever they like, and ultimately they can override any objections from the House of Lords. This is what Lord Hailsham meant when he said we live under an elective dictatorship. In other words, there are effectively no limits on what a government can do. So just in case you're not aware of this term before, elective dictatorship, really he's talking about the fact that we have a parliamentary system of government. So the government of the day usually has an inbuilt majority in the House of Commons, not always. But assuming it has a majority in the House of Commons, and assuming its party whips are doing their job and the government has control of its own MPs, then it can push through whatever legislation it likes. It doesn't. The House of Lords can't veto it. It can override the House of Lords. The head of state can't stop it. Can't veto legislation. The Queen, by convention, is obliged to sign any law that comes on her desk that's been passed by Parliament. There's no constitution that the government, a codified constitution, the government has to respect. So the judges can't strike down legislation as they can in the US. So really, there's no limits at all on what a government can do, so long as it has that majority in the House of Commons. Now, so this is a dangerous situation for the country's citizens to be in, as their rights can be trampled in an instant if a government calculates it will be to their advantage. Now, even the Human Rights Act that we do have does not provide adequate protection for two reasons. Firstly, if judges rule that parliamentary legislation contravenes the Human Rights Act, breaches the Human Rights Act, they only have the power to recommend that Parliament repeal the offending legislation. They can't actually enforce this. Parliament, therefore, can ultimately ignore such rulings. And secondly, the Human Rights Act does not offer adequate protection because the Human Rights Act itself can be repealed at any time with a simple majority vote in Parliament, as indeed the Conservatives have actually a manifesto pledge to do exactly this and scrap the Human Rights Act. So the liberal argument is our rights without a codified constitution that firmly codifies and entrenches our rights are very precarious and vulnerable and are being eroded already. Okay, that's the point. Supporters of the status quo, however, supporters of keeping things as they are, uncodified, argue that a codified constitution would give judges too much power. So who are looking at the issue of power? Because judges will be able to overrule acts of Parliament that they deem to be unconstitutional. If you're going to have a codified constitution, a kind of set of binding rules that even the government must abide by, then of course you need someone to enforce those rules. And who enforces the law is the judges. So the argument, actually, a codified constitution would give the judges too much power. So those making this argument, they argue that the Human Rights Act actually has already given judges too much power. And a codified constitution would greatly exacerbate this, make it worse. So, for example, the 2001 emergency legislation we referred to before that allowed foreign nationals to be detained without charge indefinitely. There was what's called a judicial review of that legislation, which is when judges look at government action or a piece of legislation to check that it's legal, that it's in line with other legislation, and so on. And the judicial review of this legislation in 2001 ruled that it was indeed a breach of the Human Rights Act. In 2004, judges ruled this emergency legislation breached the Human Rights Act. Now, and therefore they recommended that Parliament do something about that. And indeed, Parliament did repeal that legislation in 2004. So some people argue, well, this is particularly galling because judges are unelected. And under a codified constitution, they'd have the power to overrule the elected House of Commons. So this is anathema to the basic principles of democracy, that you'd have an unelected institution overruling an elected institution. So you can see this in the US. Very often the Supreme Court will, the term is strike down legislation or parts of legislation passed by the elected Congress because they argue it's unconstitutional. And even presidential decrees and so on. You remember President Trump got in trouble over his so-called Muslim travel ban. The Supreme Court, the judges at one point wanted to overturn some aspects of the travel ban and so on. So supporters of our current uncodified constitution say, no, we don't want this situation here, where unelected judges can actually strike down legislation passed by the elected parliament. However, liberals would argue the current situation is more dangerous because it gives the executive branch of government power to abuse people's rights. They argue, well, it's overblown, this argument about judicial power. They said the judges can't just make any decisions they please. Their role is simply to ensure that all the institutions of government abide by the Constitution. So it's not a case of unelected judges just saying, we don't like this legislation, let's scrap it. They can only, with a codified constitution, they'd only be able to strike down legislation if it breached the Constitution. They don't create the rules of the Constitution either. That would be the role of the elected representatives. All the judges would do would make sure those rules are respected. So on those grounds, many would argue it's a good thing that US courts, for example, in the early stages tried to block some aspects of the travel ban, ensured the right of freedom from discrimination was upheld, right, as is supposed to be according to the US Constitution. So liberals argue the British executive, the British government, has too much power. It can effectively do whatever it pleases without reference to any constitutional principles. If they wish to do something that's unconstitutional, all they need to do is use their majority in Parliament to just do it, and then the Constitution will kind of automatically, therefore, have been changed. Now, the situation is made worse by the fact that there are so many grey areas in the Constitution, vagueness, right, which can be abused by governments, particularly in the area of conventions, which are unwritten rules. So there's no written document you can refer to clear up any misunderstandings or different interpretations. So, for example, many constitutional scholars have argued that since Tony Blair put the Iraq War to a parliamentary vote in 2003, this established a new constitutional convention, meaning that parliamentary consent is now required for all military interventions. However, when David Cameron wanted to deploy special forces in Libya in 2016, and indeed he did deploy them, and he argued that his royal prerogative powers allowed him not to consult Parliament. So here we have two contradictory conventions. We have, on the one hand, an unwritten convention, part of the royal prerogative powers, that the Prime Minister does have the power to deploy troops without consulting Parliament. And on the other hand, we have supposedly a new convention developed since 2003 that actually Prime Ministers should consult Parliament before they deploy troops. Now, actually, it's interesting. In 2013, David Cameron respected this new convention. He wanted to bomb Syria, but he sought parliamentary consent first, and Parliament vetoed it. And he said, okay, I won't do it. I respect parliamentary sovereignty. But then 3 years later, he decided he wasn't going to consult Parliament. He just deployed troops in Libya without asking. So we have these contradictory areas within the UK Constitution, particularly around the conventions, and governments can abuse them to suit their own interests. Now, a codified constitution would clarify all of this. Other arguments against the adoption of a codified constitution, however, have included the argument that the process of creating a constitution would be too costly and too time-consuming. Take a long time to put all these conventions together, maybe have the discussions around all the different interest groups, maybe the whole population of the country have to get involved in having their say what should be in the constitution and so on. People argue there are other priorities right now, an era of austerity when basic services are not even able to get the money they need. This is not a good use of resources and time. Professor Vernon Bogdanor has added an additional part to this argument. He's probably the country's leading expert on the UK Constitution. He's a professor here at Oxford, David Cameron's tutor at Brasenose College. Now, Professor Bogdanor argued that even if a codified constitution was a good idea in principle, he argues now is not the time to create one. There's too much unresolved business to make it a sensible proposition right now. And he argues that much of the constitution remains in flux, undergoing change right now, for it to be not sensible to try to set it in stone right now when so many things are still unresolved. So think, for example, of the issue of the House of Lords. Should we have an elected second chamber? You know, Tony Blair began the process of reforming the House of Lords in 1999, but it's still unfinished business. There's general agreement amongst most parties there should be some kind of elective process within the House of Lords, but it hasn't happened. Other unresolved issues or ongoing issues include those around the powers of the devolved parliaments. The powers every few years since devolution, new powers have been awarded to one or other of the devolved assemblies. And you've still got other outstanding issues around devolution, such as the West Lothian question, the kind of mismatch between Scottish MPs who can vote on matters affecting English people, but English people can't vote on matters affecting Scottish people. This has partially been resolved by the issue of English votes for English laws, but there's still these outstanding issues. And of course, the big one is Brexit. You know, and so many people say with all of these unresolved issues, it doesn't make sense to try and set in stone, you know, principles of the Constitution that are supposed to have some kind of permanence when there's so many unresolved issues still outstanding. However, and liberals again in particular argue that this misses the point, that actually creating a codified constitution would itself be the perfect opportunity to resolve these issues. The process of creating the rules by which we should be governed, they argue, will be a great way to boost participation and education. It would spark a national debate about what the rights of citizens should be, how our representatives should be chosen, how the various nations of the UK should relate to one another and their different powers. Now, the discussion might be lengthy, might be time-consuming, but liberals argue it's well overdue, and it would have a hugely positive impact on producing a more active and more engaged and more participative citizenry, aware of their rights and the government's responsibilities because they help formulate them. So in conclusion, the arguments in favor of a codified constitution do indeed outweigh the arguments against, now more than ever. The dangers of an unrestricted executive are becoming increasingly apparent as the executive abuses its power to undermine long-established rights, legalize mass surveillance, and wage secret wars around the globe. With the rise of the extreme right across the continent, the need for clear limits on executive power is even greater than ever. Indeed, the US is very lucky to have a codified constitution in the Trump era, restricting Trump's excesses. Were a similar figure ever to come to power in Britain without clear constitutional limits to their power, God help us. Thank you.